This week on the Journal editorial report, the deadline draws near as both parties haggle over a debt limit deal. But is a government default really an option? Plus, is Janet Yellen good for the economy? What President Obama's Fed nominee means for your money? And a pair of terror raids end with a big al-Qaeda capture in Africa and reignite the political debate over Guantanamo Bay here at home. Welcome to the Journal editorial report. I'm Paul Gigot. Well, with October 17 fast approaching, both sides are scrambling to reach at least a short-term deal to raise the federal government's borrowing limit. President Obama this week painted a bleak picture should Congress fail to reach an agreement on the debt ceiling before Thursday's deadline.
If Congress refuses to raise what's called the debt ceiling, America would not be able to meet all of our financial obligations for the first time in 225 years. Nobody in the past has ever seriously threatened to breach the debt ceiling until the last 2 years. And this is the creditworthiness of the United States that we're talking about. This is our word. This is our good name. This is real.
But thanks to the 14th Amendment, constitutional attorney David Rivkin says the default on the federal debt is not even a possibility. I spoke with him earlier and asked him why.
The United States is the only country that is constitutionally incapable of default. Section 4 of the 14th Amendment says specifically that public debt of the United States authorized by law cannot be questioned. The Supreme Court in a case called Perry versus United States construed this language in 1935 and made very clear that this language is judicially enforceable. So individuals who hold bonds and other obligations of the United States,
right.
If the United States misses principal interest payment, you can go over to the Federal Court of Claims and get a money judgment against the United States. It's not debatable.
All right. And that was the last case the Supreme Court heard on this question.
Well, except in 1960, in a case called Nestor versus Fleming, the court made clear, Paul, that it only applied to true public debt, that other obligations of the United States are not similarly protected.
Particularly Social Security payments or things like that. But, David, when I was in school, I was always taught that Congress has the sole power under the Constitution to appropriate money. Wouldn't this interpretation of the 14th Amendment give the president the opportunity, essentially, to spend money not appropriated by Congress?
You would not, Paul, for a couple of reasons. First, as a practical matter, there's more than enough money in the Treasury from tax receipts to pay debt service, $200+ billion in receipts, roughly $30+ billion in debt service.
Right.
Second, this language is a limitation on what political branches can do relative to repudiating existing debts. It is not a language that grants president any power to either raise debt or come up with other sources of revenue. That power is very much in Article 1.
So this would not, just to be clear, this would not be a precedent for the president to say, you know what, I can now take that tax revenue that you say there's plenty of and spend it on Social Security payments or Medicare payments or the Education Department or whatever he wanted to. This would only apply to debt interest payments. Is that correct?
And principle, absolutely. It applies to true public debt. And if you think about it for a second, and this is what the Supreme Court said in Nestor versus Fleming, other obligations of a sovereign, other promises are not constitutionally protected. Otherwise, you have a one-way ratchet, Paul. Congress can never decrease Social Security payments. Congress can never change COLAs. Congress can never change all the other forms of federal largesse. No, we're talking about the true public debt. But remember, this is the most important thing. This is what this, to me, utterly specious language about default is. This is not about other payments. It's about obligations of the United States held by third parties.
It's about honoring contracts for T-bills, Treasury notes, that sort of things that are a form of contract. That's what it basically enforces. Would it allow the president to roll over debt and issue new debt?
Only, well, not issue new debt, but meeting payments. I mean, roll implies that you pay off the old debt and you incur new debt. So one half of a transaction, Paul, would be allowed. You do have to pay the principal, but not incur new debt without congressional blessing. The power to borrow money in the credit of the United States under Article 1, Section 8 belongs to Congress and Congress only.
Okay, as you know, as in all legal questions, there's a dispute. Not everybody agrees with you, including, according to what I hear, the administration, which the Treasury Secretary Jack Lew and the spokesman and the White House spokesman Jay Carney both say, we don't agree with this interpretation of the 14th Amendment. What happens if they would say, you know what, we don't agree with that, so we are not going to meet our interest payments if the debt limit is breached?
Two answers. First of all, they've been very careful about it. I would bet you a lot that if you go to Office of Legal Counsel, the Justice Department, or the ultimate president's lawyers and ask for their opinion, in light of a language of Section 4, in light of a history of how it was drafted, its ratification, and the Supreme Court case law I'm talking about,
right,
they would not say that that is not the case. So the White House is straddling the fence. But second, what's stunning to me, think about how unusual it is. Prime ministers of Greece, Italy, Spain, countries with really, really bad debt problems,
right,
always talk up their debt, their credit worthiness. We seem to be the only country where political leaders are talking down our credit worthiness. That's unthinkable.
And they're doing that, and you think they're doing that for political reasons to give themselves maximum leverage and to box in the Republicans.
Absolutely, and particularly to use the business community and Wall Street to pressure the White House. Let me say briefly, the true significance, as far as I'm concerned, of this crisis is not a failure to pay public debt, but rather an across-the-board 40% sequester because we're borrowing 40 cents on the dollar. That would be very bad, but it's not about dishonoring public debts of the United States.
So
and the White House... Yeah.
And the White House knows this, and you are, so basically, if you got to the end and there was a question of breaching the debt limit, you think they would go with you in invoking the 14th Amendment?
I think they would have to go with me. Now, one last point. I've heard an argument made, sort of Paul, that somehow Treasury is such a clumsy beast that they cannot prioritize the payments. I find it stunning. I don't know of any bank in the world that does not know how to segregate different payment streams.
All right, David Rifkin, thanks so much for being here. We'll be watching.